Greetings and good evening, beautiful people. Thank you so much for joining us this evening. Hope you're having a fantastic day and week. Welcome to our live weekly YouTube readings of the final report of the California Reparation Task Force right here on the CJEC YouTube channel. This is the only live reading of the California Reparation Task Force final report on YouTube. The final report of the first in the nation California Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s. Equally important is also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing every page of it to you, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California. CJEC is California's leading grassroots organization for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California state prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now, I need you to do three things. First, connect to our YouTube channel by liking this video, hitting the bell for reminders, and subscribing to our YouTube channel. Second, get connected to us on social media by following CJEC on Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Finally, get informed and involved. To do that, visit www.cjec-official.org to sign up for current and accurate California reparations news and info on our Get Involved page, and support our work by volunteering and or donating. To donate, just click the Donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. You can learn more about our fiscal sponsor, the California Black Women's Health Project, at www.cabwhp.org. By way of introduction, my name is Iris. I live in Santa Rosa. I'm from the Bay Area, California, and I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. The agenda for today, Chapter 39, Statutes and, Chapter 39, Unjust Legal Systems, Statutes, and Case Law. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website, www.cjec-official.org/reports. Okay, we are just about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch their readings of the first report on their channel at ETM Media Group on YouTube and on our website at www.cjec-official.org/videos. Second, for those of you who don't know, historic reparations legislation in California is here and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by Senator Stephen Bradford and will move forward this year. To read the bill, visit www.cjec-official.org/advocacy. Third, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During this 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So to make reparations a reality in California, the math is 41 plus 21 plus 1. That is 41 assembly members, 21 senators, and one governor. 41 plus 21 plus 1 equals reparations in California. Lastly, but not least, special thanks to CJEC's reparations organizing and mobilizing team, specifically our volunteer final report readers. And without further ado, Chapter 39, Part 3 of the California Reparations Task Force Final Report. Chapter 39, Unjust Legal System, Statutes and Case Law, Part 3, page 1033. Moore versus New York, 333 U.S. 565. Summary of facts and issues. Several African American defendants convicted of murder by a special jury challenged New York's special jury selection process, which impaneled only the best or most intelligent of potential jurors. Prosecutors impaneled 150 jury members. None were African American. The court upheld the conviction, determining that the defendant's counsel was present at the jury selection stage and that the names were drawn without objection. The court concluded that African Americans comprised less than 2% of the population of the county at the time, and that there was no evidence of systemic, intentional, and deliberate exclusion of African Americans from jury duty. As a result, the judgment was affirmed. Impact of ruling. The dissent highlighted that the jury comprised neither a jury of the defendant's peers nor a fair cross-section of their community. Although the jury process of only selecting the quote best unquote jurors was race neutral, its application had a systemic impact of excluding African American jurors. 1950, Cassell versus Texas, 339 U.S. 282. Summary of facts and issues. An African American man convicted by an all-white jury challenged his conviction, alleging that Dallas County jury commissioners for 21 consecutive jury lists had consistently limited African Americans selected to serve on grand juries. The commissioners claimed that they did not know any African Americans who qualified for jury service, at the same time admitting that they chose jury members only from those whom they were personally acquainted. The court overturned the conviction on the basis of unlawful systematic exclusion of African Americans from juries, holding that African Americans are denied the equal protection of the laws when indicated by a grand jury from which African Americans as a race have been intentionally excluded. Impact of ruling. The court held that a practice of only selecting jurors who are personally known by the jury selectors violates the 14th Amendment, and that jury commissioners have an obligation to familiarize themselves fairly with the qualifications of eligible jurors of the county without regard to race or color. 1953, Brown versus Allen, 344, U.S. 443. Summary of facts and issues. Several African American men convicted of various capital offenses in different cases asserted a range of claims as to the exclusion of African Americans from their juries and the extraction of confessions from the accused. One petitioner, Brown, alleged discrimination in the selection of grand and trial jurors, which were based on tax records. Brown contended that no more than one or two African Americans had served on a grand jury panel and that no more than five had served on a trial jury in the county. Another petitioner, Speller, likewise challenged his conviction on the grounds of racial exclusion of potential jurors. In Speller's case, the names of potential jurors were placed in a box with a dot next to African American jurors' names, and the county had no African American jurors in any recent case, including Spellers. Impact of ruling. The court held that the petitioners did not provide sufficient evidence of systematic discrimination, and a mere showing of disproportionality was not sufficient to merit a granting of a writ of habeas corpus. The tax lists in the case of Brown were the most comprehensive list of names available. In Speller's case, a child drew the names of the potential jurors in public, convincing the court that no discrimination had occurred. Avery versus State of Georgia, 345 U.S. 559. Summary of facts and issues. Petitioner, an African American man, was convicted of rape and sentenced to death in Fulton County, Georgia, by an all white jury. He challenged the jury selection process, which involved pulling slips of paper out of a box. The names of potential white jurors were written on white slips, and the names of African American potential jurors on yellow slips to be selected by the judge and sent to the clerk for processing. Impact of ruling. The Supreme Court did not find racial discrimination in the selection of the slips, but in the process itself. The fact that not a single African American was chosen presents a prima facie case of discrimination, and the use of different colored slips made it easier to discriminate. The court ruled that once a defendant establishes prima facie case of discrimination, it is the state's burden to present sufficient evidence to dispel the prima facie case, regardless of whether the defendant has proven a particular act of discrimination by a particular person. 1961, Monroe versus Pape, 365 U.S. 167. Summary of facts and issues. 13 Chicago police officers broke into the African American petitioner's home early in the morning without a warrant. After forcing the petitioner to stand naked in one room while they ransacked the home, officers took one of the petitioners to the police station where he was interrogated for 10 hours about a murder. He was then released without charges. The petitioners filed an action under 42 USC Section 1983 against the police officers and the city of Chicago for violating their rights under the color of law. The lower court dismissed the city and the police officers. The petitioners appealed. The United States Supreme Court reversed in part and affirmed in part. Specifically, it held that the police officers acted under the color of law when they entered the petitioner's home and conducted an unreasonable search and seizure, and they could be held individually liable under Section 1983. Accordingly, it reversed that aspect of the lower court's decision. It affirmed the part of the decision dismissing the city of Chicago because a municipality could not be liable under Section 1983. Impact of ruling. The court examined the legislative history of Section 1983 to conclude that in passing the statute, Congress intended to permit citizens to sue officials who violate their constitutional rights. The same could not be said for municipalities, however, because municipalities are not, quote, persons, unquote, within the meaning of the statute. Subsequent history. Monroe versus Papes holding that municipalities are immune from liability under Section 1983 was overruled by Monroe versus Department of Social Services of City of New York, 1978, 436 U.S. 658, 701. Mapp versus Ohio, 367 U.S. 643. Summary of facts and issues. This case arises out of a search that was conducted without warrant. 3 police officers arrived at appellant's residence based on information that, quote, a person was hiding out in the home who was wanted for questioning in connection with a recent bombing, and that there was a large amount of policy paraphernalia being hidden in the home, unquote. When the officers demanded entrance, they were refused. They returned later and forcibly entered the home without a warrant and searched it, where they found obscene materials. Petitioner was arrested and later convicted. The United States Supreme Court reversed the conviction. The court held that the right to privacy embodied in the Fourth Amendment is enforceable against the states, and because it is enforceable in the same manner as other basic rights secured by the Due Process Clause, the exclusionary rule applies to violations of that right. Quote, our decision, founded on reason and truth, gives to the individual no more than that which the Constitution guarantees him, to the police officer no less than that to which the honest law enforcement is entitled, and to the courts that judicial integrity so necessary in the true administration of justice. End quote. Impact of ruling. The court held that the exclusionary rule applied to state violations of right to privacy. The Fourth Amendment's right to privacy is enforceable against states through the Due Process Clause of the 14th Amendment. The exclusionary rule, which applies to federal government's violation of right to privacy, also applies to violations of the right by the state. 1964, Bowie versus City of Columbia, 378 U.S. 347. Summary of facts and issues. This case arose of a, quote, sit-in, unquote, demonstration at Eckerd's drugstore in Columbia, South Carolina. The petitioners, 2 African-American college students, took seats in the restaurant at Eckerd's and waited to be served. After they were seated, an employee who did not speak to them put up a, quote, no trespassing, unquote, sign. Petitioners continued sitting at the booth, and the store manager called the police to remove them. After the police arrived, the petitioners were asked to leave again. When they refused to leave, they were arrested and later convicted of trespass. After the state court affirmed their convictions, they sought review in the Supreme Court on the grounds that their convictions violated due process and equal protection. The Supreme Court reversed their convictions on due process grounds, finding they did not have fair warning that the conduct for which they were convicted was rendered criminal by a South Carolina statute. Impact of ruling. The court's decision affirmed that due process requires fair warning of conduct that is a crime. 1966, Davis versus North Carolina, 384 U.S. 737. Summary of facts and issues. Petitioner, an African-American, was tried and convicted on a charge of rape murder. The prosecution offered a written confession and testimony regarding an oral confession made to law enforcement into evidence at the trial. Petitioner's counsel objected on the grounds that the confessions were not freely and voluntarily given. After hearing testimony, the trial judge ruled that the confessions were voluntarily made and admitted them into evidence. The jury returned a verdict of guilty without a recommendation for life imprisonment, and the petitioner was sentenced to death. The Supreme Court reversed his conviction. The confessions were the end product of coercive influences, including a 16-day detention during which he was not advised of any rights and subjected to repeated interrogations while isolated from everyone but the police. Due process required the reversal of his conviction. Impact of ruling. Because of the non-retroactivity of Miranda versus Arizona, the court relied on the due process clause of the 14th Amendment and its voluntariness standard to find the interrogation of defendant who was an impoverished African American with a third or fourth grade education was unconstitutional. The case established that Miranda did not alter due process concerns of voluntariness. Therefore, common police interrogation tactics, which often relied on the accused not knowing their rights, would continue to be reviewed under the 14th Amendment. 1967. Wittis versus Georgia, 385 U.S. 545. Summary of facts and issues. The defendants, African American men convicted of murder by all white juries, filed petitions for writs of habeas corpus challenging the compositions of the grand juries or the grand and trial juries. In selecting the jurors, the jury commissioners have followed Georgia law, in which the grand and trial jury lists were pulled from county tax digests, which were segregated by race and chosen by court employees, as well as from personal acquaintances of the commissioners. 27% of the taxpayers of the county were African American, of whom zero were selected for trial jury, and one of whom was selected for the grand jury. Impact of ruling. The court followed its ruling in Avery versus State of Georgia, 1953, 345 U.S. 559, finding a racially segregated jury selection system based on tax rolls to be unconstitutional violation of the defendant's 14th Amendment rights. This system, combined with the selection of personal acquaintances of the commissioners, provided an opportunity for discrimination, regardless of the intent of the commissioners or the race neutrality of the face of the law. The court also affirmed that a defendant has the burden to provide the existence of purposeful discrimination. Once a prima facie case has been made, the burden shifts to the prosecution. Sims versus Georgia, 389 U.S. 404. Summary of facts and issues. Petitioner, an African American man, was convicted of rape and sentenced to death by an all-white jury. Police had detained him for more than 8 hours, depriving him of food and refusing access to counsel. The court affirmed the holding in Witts versus Georgia, 1967, 385 U.S. 545, that confessions produced by violence or threats of violence are involuntary and cannot be used against the person giving them. Additionally, the court ruled that the defendant's equal protection rights were violated where jury commissioners selected jurors they personally knew from county tax rolls that separate taxpayers by race, and the percentage of African Americans on the tax digests were much higher than on the jury lists. Impact of ruling. The court again affirmed that purportedly race-neutral system of jury selection that relies on personal acquaintances can violate the 14th Amendment. 1968. Terry versus Ohio, 392 U.S. 1. Summary of facts and issues. A police officer conducted a quote stop and frisk unquote of two men who they suspected planned a robbery. The officers had neither a warrant nor probable cause, but merely observed the men quote casing unquote a location. Petitioner Terry argued that the quote stop and frisk unquote was a violation of his Fourth Amendment right, protecting him against unconstitutional searches and seizures. Impact of ruling. The U.S. Supreme Court held that police can conduct a quote stop and frisk unquote without a warrant as long as they have reasonable suspicion that a person committed a crime and may be armed. This ruling created a new category of government searches and seizures based on quote reasonable suspicion unquote that remain constitutional under the Fourth Amendment. Subsequent history. In Minnesota versus Dickerson, 1993, 508 U.S. 366, 376 through 377, the court explained the holding in Terry and held that the officers may confiscate non-threatening contraband detected during a Terry pat-down search, so long as it did not exceed the bounds of Terry, i.e., the protective search may not go beyond what is necessary to determine whether a person is armed. 1970, Cebron versus New York, 392 U.S. 40. Summary of facts and issues. This state considers two separate situations that involve the constitutionality of New York State's quote, stop and frisk, unquote, practice. The appellants were convicted of crimes in state court on the basis of evidence seized from their persons by police officers. The Court of Appeals of New York held that the evidence was properly admitted on the grounds that the searches that uncovered it were authorized by the statute. Impact of ruling. In one appellant's case, the court refused to permit the search of a drug suspect who police had no reason to believe was armed and dangerous. Quote, the police officer is not entitled to seize and search every person he sees on the street or of whom he makes inquiries, unquote. The court provided guidelines for law enforcement to follow in order to search and arrest suspects. The court found that the officer's search was not reasonably limited in scope to accomplish only the goal that justified the search, protecting the officer by disarming a potentially dangerous person. As a result, the search violated the Fourth Amendment. By contrast, in the other appellant's case, the court noted the officer properly considered furtive actions and flight, as well as specific knowledge relating to the suspect to evidence of crime in the decision to make an arrest. The search was thus reasonable because it was properly incident to a lawful arrest. Carter versus Jury Commission of Greene County, 396 U.S. 320. Summary of facts and issues. A group of African American citizens of Greene County, Alabama, filed a class action against the governor and county officials, alleging that they were wrongfully excluded from the jury rolls because of their race. Under Alabama's juror selection statutes, the governor appointed a 3-member commission for each county. The commission employed a clerk who is charged with obtaining the name of every citizen in a county between the ages of 21 and 65. The commission then prepared a jury roll containing the names of all citizens, quote, generally reputed to be honest and intelligent and esteemed in the community for their integrity, good character, and sound judgment, end quote. In this case, the clerk did not gather all the names of potentially eligible jurors, but relied on previous year's roll, adding new names from suggestions from the commissioners. While the population was 75% African American, only 7% of the names on the jury list were African American citizens. Impact of ruling. The Supreme Court noted that this was its first case in which African American plaintiffs sought affirmative relief from a discriminatory justice or jury system rather than a criminal defendant seeking relief from a conviction. The court held that Alabama's jury system was valid, even though the application of the law resulted in the exclusion of African American jurors. However, the court upheld the lower court's order regarding the administration of the juror selection statute, requiring that the county compile a new jury roll composed of all eligible citizens of the county. Evans versus Abney, 396 U.S. 435. Summary of facts and issues. A park in Mason, Georgia, was open to white residents only based on the provisions of a testamentary trust. In Evans versus Newton, 1966, 382 U.S. 296, the court held that the city could not continue to operate the park in a segregated manner without violating the 14th Amendment. Therefore, the trust failed and the property returned to its heirs. African American citizens who sought to integrate the park appealed this holding, arguing that closing the park violated their 14th Amendment right to equal protection under the law. Impact of ruling. The U.S. Supreme Court upheld the closing of the park. In reaching this decision, the court distinguished the facts from its landmark holding in Shelley versus Kramer, 1948, 334 U.S. 1, where it ruled that it was unconstitutional for a court to enforce a racially discriminatory land covenant. In Evans, the court applied race-neutral principles and said the destruction of the park was constitutional because it eliminated all discrimination against African Americans, and the laws applied equally to white and African American citizens in Mason. 1971, Bivens versus 6 unknown name federal narcotics agents, 403 U.S. 388. Summary of facts and issues. 6 Federal Bureau of Narcotics agents entered and searched Bivens' home and arrested him without a warrant. The agents then booked him and subjected him to a visual strip search. In addition to the allegations of Fourth Amendment violations, Bivens, an African American man, sued each of the agents for damages for humiliation and mental suffering. The agents argued that they were immune from suit via government privilege because they acted under federal authority. Impact of ruling. The court held that Bivens did have a private right of action for money damages against federal officers for Fourth Amendment violations, recoverable upon proof of his injuries. This case maintains federal court access for private citizens to file claims against federal government officials for some constitutional violations. Subsequent history. The court initially extended Bivens to allow plaintiffs to bring actions against federal officers for Fifth and Eighth Amendment violations. In recent years, the court limited Bivens by holding that it cannot apply in new contexts. 1972, Adams versus Williams, 407 U.S. 143. Summary of facts and issues. Relying on an informant's tip that Williams was illegally carrying a gun and narcotics, a police officer approached Williams' car and reached in when Williams rolled down his window and removed a gun from his waistband. The officer then arrested Williams and searched his car, finding drugs. Williams was convicted, and after the Supreme Court of Connecticut affirmed, Williams challenged the conviction on the ground that the state was imprisoning him unlawfully based on evidence that should not have been admitted at trial. Impact of ruling. The U.S. Supreme Court held that a police officer may conduct a search based on an informant's tip alone. This allows officers to exercise discretion when determining whether the suspicion is sufficient or reliable. Subsequent history. The court used the reasoning in Williams to justify its holding in Illinois versus Wardlow 2000, 528 U.S. 119. In Wardlow, a person fled when they saw a police officer in a high crime area, and the court found the police's subsequent stop and search was reasonable based on the person's suspicious behavior, even if they acted out of intimidation or fear. Alexander versus Louisiana, 405 U.S. 625. Summary of facts and issues. Defendant, who was convicted of rape and sentenced to life in prison, challenged the selection method used to form the grand jury. The grand jury pool of 20 had one African American, but the grand jury itself was all white. And informing the grand jury, the jury commissioners collected from potential jury members approximately 7,000 questionnaires, which contained a space to indicate the race of the recipient, and later excluded many because they were deemed not qualified or exempted from service. They then relied on the remaining 2,000 questionnaires to randomly select 400 people to serve on the grand jury. Of those selected, only 27 or 7% were African American. The parish population was 21% African American at the time. Impact of ruling. The court held that while there is no numbers base standard for determining systemic exclusions of African Americans from juries, there was unfair racial discrimination in this grand jury process. The racial designation on the questionnaires provided a clear and easy opportunity for discrimination, even if the defendant could not point to a specific instance of discrimination. The opportunity is sufficient to establish a 14th Amendment violation. Peters versus Kiff, 407 U.S. 493. Summary of facts and issues. Peters, a white man convicted of burglary, challenged the systemic exclusion of African Americans from the juries that indicated and convicted him. The state argued that Peters was not entitled to a reversal of his conviction because he did not provide affirmative evidence of actual harm. Impact of ruling. In a case of first impression, the court ruled that a white defendant could challenge the systemic exclusion of African American jurors. The fact that juries were illegally constituted was sufficient to establish a 14th Amendment violation. This decision benefited African American defendants as well by strengthening the principle that a jury must be composed of a representative, a cross-section of the community, and that any defendant is harmed by the systemic exclusion of jurors of any race on the basis of their race, regardless of whether they have demonstrated actual harm resulting from the exclusion. Subsequent history. In Hobby versus United States, 1984, 468 U.S. 339, 350, the court held that assuming discrimination entered into the selection of a federal grand jury foreman, such discrimination did not warrant the reversal of the conviction of and dismissal of the indictment against a white male bringing a claim under the Due Process Clause. 1973, Ham versus South Carolina, 409 U.S. 524. Summary of facts and issues. Defendant Ham, who was convicted of the possession of marijuana, challenged his conviction because the trial judge refused to examine jurors on voir dire as to their racial prejudices. His counsel had asked the judge to ask potential jurors 2 questions regarding their racial biases, a question related to possible prejudice against beards, Ham was bearded, and a 4th question regarding publicity about drugs. The judge refused to ask any of the questions. Ham's defense was that the state was targeting him for his civil rights activities. Impact of ruling. The court held that the 14th Amendment and circumstances of this case required the judge to interrogate the jurors on the subject of racial prejudice. The 14th Amendment ensures essential demands of fairness. The court found that to advance this fairness, the trial court, while not requiring to ask the specific questions of defendant's counsel, must at least make an inquiry since the defendant relied on an argument that he was racially profiled. Subsequent history. The court soon clarified that the Ham decision would be construed narrowly. In Restaino versus Ross, 1976, 424 U.S. 589, 597, the court held that the Constitution did not always entitle a defendant to have questions posed during voir dire on the issue of racial bias. This entitlement materialized in Ham because racial issues were inextricably bound up with the conduct of the trial. End quote. Davis versus United States, 411 U.S. 233. Summary of facts and issues. Davis, an African-American federal prisoner, was convicted by an all-white jury. He made an ultimately challenge to the composition of the grand jury under a federal habeas corpus proceeding, arguing that the unconstitutional discrimination precludes the timeliness requirement. Impact of ruling. The court found that a motion to dismiss a conviction on the basis of exclusion of qualified African-American jurors brought 3 years after the conviction could be denied as untimely. The court held that an allegation of deprivation of constitutional rights was not sufficient to overcome an explicit timeliness waiver contained by the federal rules of civil procedure. Tollett versus Henderson, 411 U.S. 258. Summary of facts and issues. Defendant was indicted by an all-white jury for murder and pleaded guilty on advice of his counsel, receiving a sentence of 99 years in prison. Years later, he petitioned for habeas corpus, claiming that his confession had been coerced and that he had ineffective assistance of counsel. Impact of ruling. The court held that state prisoners cannot make a separate claim of discrimination in grand jury selection when they had already pleaded guilty with their lawyer's advice. However, they could challenge their guilty plea if they could prove that their counsel gave them advice outside of the range of competence demanded of attorneys in criminal cases. The court remanded the habeas petition to the lower court to determine whether counsel's advice was within the range of competence. 1975, Johnson versus Mississippi, 421 U.S. 213. Summary of facts and issues. 6 African-American men boycotting businesses in Mississippi for racial discrimination in employment were arrested and charged with conspiracy to bring about a boycott. The petitioners sought to remove the case to federal court, arguing that the underlying charges were unconstitutional and in violation of the Civil Rights Act of 1968, which protected their right to participate and encourage participation in boycotts. Impact of ruling. The U.S. Supreme Court found that Civil Rights Act of 1968 did not apply to state prosecutions, but only crimes of racial violence. Petitioners did not have a right to be free from arrest and prosecution for federally protected conduct. Since there was no federal statutory authority, petitioners could not bring the case in federal Court. 1976, Restaino versus Ross, 424 U.S. 589. Summary of facts and issues. An African American man, Ross, was tried for crimes against a white man. During voir dire, the trial court was mandated by statute to inquire generally into prejudice, but the trial court judge refused. Ross appealed, alleging his federal constitutional rights were violated because he was denied the opportunity to inquire about racial prejudice. Impact of ruling. The U.S. Supreme Court held that questioning potential jury members during voir dire about racial prejudice is not required under the Constitution and can be made on a case by case determination. Subsequent history. The court later held that defendants in interracial capital cases are entitled to question jurors about potential racial bias. Francis versus Henderson, 425 U.S. 536. Summary of facts and issues. An African American man convicted of felony murder filed a habeas corpus petition in federal court 6 years after his conviction, alleging his trial was unconstitutional because African American jurors were excluded from the grand jury that indicted him. Impact of ruling. The U.S. Supreme Court denied the petition for relief and upheld the rules set out in Davis versus United States, 1973, 411 U.S. 233, which required a showing of, quote, cause, unquote, explaining the petitioner's failure to challenge the constitutionality of the jury before trial and showcasing of actual prejudice in federal collateral proceedings. 1977, Manson versus Brathwaite, 432 U.S. 98. Summary of facts and issues. The defendant, an African American man, challenged under the 6th and 14th Amendments the admissibility of a police officer's testimony that identified him as the culpable party. Impact of ruling. The U.S. Supreme Court held the officer's identification was reliable, even though a suggestive identification procedure was used. Brathwaite established the following factors for the court to consider to regulate the fairness and reliability of eyewitness testimony. 1, the witness's opportunity to view the perpetrator at the time of the crime. 2, the witness's degree of attention. 3, the accuracy of the witness's prior description of the accused. 4, the level of certainty demonstrated at the confrontation. And 5, the time between the crime and the confrontation. These factors are to be weighed against, quote, the corrupting effect of the suggestive identification itself, end quote. 1979, Rose versus Mitchell, 443 U.S. 545. Summary of facts and issues. Criminal defendants challenged through a habeas corpus petition racial discrimination in the selection of foremen of the grand jury that indicted them, but not the racial composition of the trial jury. In support of their argument, the defendants presented evidence that there had not been an African American foreman on a grand jury in the county. Impact of ruling. The court held that if a state defendant is convicted, but the grand jury indicting them was selected based on race, the conviction can be overturned even if the trial was fair and the person convicted by a legitimate trial jury, and that these claims can be made in a federal habeas petition. Ultimately, the court ruled that the defendant did not present sufficient evidence of racial discrimination in the selection of the grand jury foreman and denied the petition. 1980, United States versus Mendel, 446 U.S. 544. Summary of facts and issues. Drug Enforcement Agency agents who were white approached the defendant, an African American woman, on a suspicion that she was unlawfully carrying narcotics. After some questioning, the agents asked her to accompany them to their office for further questioning, and she complied. After being told she had the right to decline a search, the defendant consented to a search of her person and handbag. The agents then conducted the search and found narcotics in her possession. The defendant appealed her conviction on drug charges on the ground that she never consented to the search. Impact of ruling. The U.S. Supreme Court upheld conviction and found that the woman was legally searched because she voluntarily went to the agent's office and was not under duress or coercion based on the totality of the circumstances. The court found that race had not been a decisive factor in whether the defendant freely consented to accompanying them to their office, since, quote, reasonable person, unquote, would have believed they were free to walk away when first approached by the officers. The defendant's liberty and privacy had not been restricted in violation of the Fourth Amendment. Subsequent history. In California versus Hadari D, 1991, 499 U.S. 621, the court applied the objective, reasonable person standard from Mendenhall and elaborated that a show of authority was not enough to determine that a seizure had occurred, noting that, quote, Mendenhall establishes that the test for existence of a show of authority is an objective one, not whether the citizen perceived that he was being ordered to restrict his movement, but whether the officer's words and actions would have conveyed that to a reasonable person, end quote. And that will conclude tonight's reading of Chapter 39 of the California Reparations Task Force Final Report. Before you go, if you haven't done so already, don't forget to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, don't forget to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and Twitter at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and info on our Get Involved page. Get involved. Support our work by volunteering and or donating. To donate, just click the donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Thank you all so much for your time. I appreciate you all. We are closer to reparations than we have ever been in California. Have a great night.